Welcome to the InfoSec Insider podcast, brought to you by URM, the UK's leading information and cybersecurity specialists.
Hi, my name's Annie and I'm joined here today by Stuart Skelly, who's one of our Senior Data Protection Consultants here at URM. Welcome to another episode of Talk DP. So today we're going to be looking at some GDPR back to basics, really key concepts and some key terminologies and definitions that you'll need to understand if you want to achieve and maintain GDPR compliance. So my first question for you, Stuart, is what data is considered personal data under the UK GDPR? And we're looking at the UK GDPR today, just to avoid any confusion. What data is considered personal data and is therefore subject to GDPR requirements?
Thanks, Annie. So personal data, obviously, that's what the UK GDPR is all about. So that's the most fundamental definition. Personal data is information which can identify directly or indirectly a natural person, and by natural person we mean a living human individual, and otherwise known as the data subjects. The data subjects are living human individuals. Key to that definition is this idea of direct or indirect identification. Direct is straightforward. So a photograph of someone's face, image of your face would be something which can directly identify you because it uniquely points to a single person who looks like that. Similarly, someone's name, perhaps together with their date of birth, that would information would identify that person uniquely. Indirectly is a little more nuanced. Indirect identification means that the data, when the information, when put together with additional information, can point to a single identifiable living individual. Perhaps it might be someone's address or type of car they drive, the job they do, their job title, their employer name. Any one of those single pieces of data wouldn't identify an individual, but put together, they would, or they would be capable of identifying that person, and so that is called indirect, or sometimes called jigsaw identification, because it's putting together various components, various elements of information, so that it becomes personal data capable of identifying someone. So the UK GDPR, when it's assessing whether information could be personal data, when it's combined with other additional information, as I've just described, the regulation requires that the organizations processing that data ask themselves what other information is reasonably likely to be available to anyone who receives that partial data. So anyone in the world, what information might be reasonably available to them, for example, from the internet, which they could place together with the data and possibly use it to identify someone. Now, the government's data reform bill, called the Data Protection and Digital Information Bill, which is currently before Parliament, has been for a couple of years now, that alters the definition of personal data for the UK only. It's a UK, or will be a UK Act of Parliament, as I mentioned, so that rather than what information might be reasonably available to anyone in the world to place together with the personal data, the new boundary of for assessing personal data, or parameter for assessing personal data, will be what information is likely to be available to people likely to obtain the personal data, rather than just anyone in the world. So although it sounds like quite a fine nuanced difference, that is a distinction in the Data Protection and Digital Information Bill, which will act to narrow down the definition of personal data in the UK GDPR, and make it a bit easier for UK organisations to decide what is and is not potentially personal data.
So just following on from that, the GDPR talks about this concept of special category personal data. So how is this different from personal data?
So yes, how is it different from sort of ordinary personal data, you might call it, Annie? Special category personal data, what used to be called sensitive personal data under the previous legislation, is information which would be particularly damaging to the data subject if it were, for example, disclosed without their authorization. So it's things like their health data, their racial or ethnic origin, their political opinions, religious beliefs, whether they're in a trade union, and also biometric data, when it like fingerprints or eye scans, when they're used to identify a unique individual. Also things like a person's sex life or sexual orientation, that they are obviously special category data as well.
How do the requirements for processing special category personal data differ from just normal personal data?
There's a heightened requirement which organizations which are processing this special category personal data have to meet. So if organizations, controllers or processors are processing personal data, they have to have at least one what is called lawful basis from Article 6 of the UK GDPR. And those are 6 grounds for processing anyone's personal data lawfully, and they have to have at least one of those, as I mentioned. With regard to special category data, there's an additional bar which the processing organisation has to clear, Annie, in that they have to have not only an Article 6 lawful basis, but also a condition from Article 9, paragraph 2 of the regulation, and that's a more restricted possible grounds for processing. So it's like an additional hurdle, as I say, that organizations wishing to process special category personal data lawfully have to clear. So to give you an example, the first of the lawful bases in Article 6 is the consent of the data subject for specific purposes. Under Article 9, the consent has to be explicit, so it's a sort of heightened type of consent. And to give another example, the very broad lawful basis of legitimate interest is available for processing ordinary non-special category personal data, but that's not available, that ground under Article 9. It's not contained in Article 9. So if you're processing special category data, you can't do it solely on the basis of legitimate interest.
So we keep talking about this idea of processing. So under the GDPR, what actually counts as processing?
Yeah, so processing basically means everything you can think of with regard to interacting with personal data, which is either accessed by automated means, i.e. held in electronic form, kept on a computer, or which is part of what the regulation calls a filing system, Annie. So if the personal data, which we've just discussed, it exists in either of those forms, anything that you do with it, so that would be collecting it, holding it, storing it, sharing it, amending it, deleting it, indeed, that counts as processing. So basically any form of interaction with data, personal data in those forms, it counts as processing, and you're right, processing is what's regulated by the UK GDPR. Interestingly, there was a case recently, it was before the European Court of Justice, in which it was found that giving a verbal or spoken job reference counted as processing. Now that's a bit counterintuitive because you think obviously it's not processing of electronic data, because you're speaking about it orally, verbally, over the telephone, for example. And this is a way in which a lot of organizations thought it was possible to avoid the provisions of the UK GDPR by simply interacting with data orally on the phone or in conversations. But this recent European court ruling found that if the information which was discussed orally formed part of a filing system, remember I mentioned that was one of the two forms that are covered by the UK GDPR. If the information was in the telephone conversation, let's say, was derived from a filing system, then that did count as processing. So, as I mentioned, it's a European level court judgment, and the UK obviously hasn't been subject to the European Court of Justice since the end of 2020, when Brexit was finalised. However, it's likely that the UK courts would at least have regards to that sort of ruling, and certainly if the question were to come up in the UK courts, counsel for the side that wanted to rely on that European Court of Justice ruling would definitely mention it. And the UK courts, although as I've said, they're not bound by the European Court of Justice's decisions anymore, they can still have regard to them, and might see that one as persuasive. So that's an interesting expansion, and perhaps counterintuitive expansion of the meaning of the term processing in UK GDPR, or rather European GDPR terms currently.
So another couple of pieces of terminology that seem to keep coming up is data controllers and data processors. So what do these two terms mean?
So the data controller is a person that's either a natural person, a living individual like you or me, or more usually a legal person, that is a legal entity like an organization or a company or a public authority. Those sorts of controllers which determine or decide the means and purposes of the processing. So controllers are, as the name says on the tin, they're in control of the personal data, and they make all the decisions about how it's used and the means and purposes of the processing. Data processors, on the other hand, they are entities or people which act on behalf of data controllers and under the written documented instructions of controllers. So whereas controllers have complete discretion within the law, of course, as to how they use personal data. Data processors are very strictly circumscribed in what they can do, because they can only process the personal data on behalf of the controller and under their explicit instructions under a contract. And the UK GDPR Article 28 says there has to be a contract, which is usually called a data processing agreement, when a controller processor relationship exists.
How do the requirements for these two types of entities differ?
The UK GDPR sets out certain obligations which are mutual. They're common to both controllers and processors, Annie. So, for example, I was talking earlier about having to have at least one lawful basis for doing the processing. That's an obligation, responsibility which binds both controllers and processors. To give another example, both the controller and processor have a duty to create and maintain what's called a record of processing activities, or ROPA, sometimes known by its initials. Although the regulations obligations on processors with regard to ROPAs are slightly lighter than they are on controllers, they both have to have a ROPA. Some provisions of the UK GDPR apply only to controllers. So, for example, the duty to provide privacy notices is a controller-only responsibility. The obligation to carry out data protection impact assessments in certain circumstances, that just binds controllers, not processors. Duty to implement technical and organizational measures to ensure compliance with the regulation under Article 24. That's a controller-only responsibility, as is the Article 25 duty to practice data protection by design and by default. Also, the duties to notify the ICO, the UK's privacy regulator or data protection authority, if there's a personal data breach. That's a controller-only obligation, and to communicate high-risk data breaches to the data subjects affected. That's also something that controllers only have to do. And now, in one of my previous answers, I mentioned data processing agreements, these mandatory contracts between controllers and processors. And under some of the mandatory provisions of Article 28, the processors have a duty to assist the controller in certain of those controller-only obligations, like the duties to report data breaches and to carry out DPIAs. So processors don't get away scot-free, as it were, on those some of those obligations. But the contract, the data processing agreement between the controller and the processor ensures, or should ensure, that the processors assist the controller organization in discharging some of its controller responsibilities.
Amazing, thank you, Stuart. And I just had one more question for you today, and it's just about cookies. So what are cookies and how do they relate to the GDPR?
So cookies, Annie, they're text files or small pieces of code which most websites seek to implant onto the devices of people who visit and use their websites. So if you're accessing a website from your laptop or from your mobile or from your handheld device. Those are the devices, what the relevant legislation calls terminal equipment, that the website operator seeks to implant or embed these pieces of code, these text files onto. And I just mentioned the relevant legislation. It's not actually the GDPR. It's another law called the in the UK, the Privacy and Electronic Communications EC Directive Regulations 2003. Now, even though, as the name states, these were passed under EU law, a directive, they're still operative in the UK after Brexit as part of the retained EU law. And those privacy and electronic communications regulations, or PEC regulations, as they're often shortened to, Regulation 6 says that if ever an entity wants to store information like a cookie onto someone else's terminal equipment, their computer hard drive, then they're under two obligations. The website operator, firstly, they have to explain in clear and comprehensive terms the purpose of the storage of the cookie, and secondly, they have to get the consent of the individual whose device it is. So the person visiting the website, for example, and the reason for implanting these cookies is that they collect data about the device which is visiting the website for the purposes of what's called tracking and also targeted behavioral advertising based on the behavior of the individual using the device when they access the website. So the information which the cookie collects and sends back to the website is things like the IP or Internet Protocol address, which is a unique identifier for the device. And IP addresses have long been considered personal data, which is why the use of cookies is relevant to the UK GDPR. They also collect information such as how long the person using the device spends on each page, which pages on the website they visit, and other aspects of their browsing behavior while they're visiting the site, which is useful, as I mentioned, for tracking and profiling and the sending of targeted behavioral advertising messages. So if website operators are going to use cookies lawfully, then they have to collect the consent, the UK GDPR level consent from the user before they implant the cookie, and that means that they have to provide what's called a cookie consent banner, which is like a pop-up banner which appears or should appear on the landing page of websites which are proposing to use cookies, which explain clearly and comprehensively what the cookies are intended for, what sorts of cookies are used, how long they will last for when they expire, because different sorts of cookies have different durations, different expiry periods. and harvest the UK GDPR level consent by means of a tick box or a check box from the user. And it's important that the user can't access any other pages of the site without having gone through that cookie banner first and either accepted all the cookies, from a position of giving freely given and informed consent to specific purposes, or they're given the option either to restrict the sorts of cookies or even to reject all cookies except the ones which are absolutely essential for allowing the website to function.
Amazing. Thank you, Stuart.
No problem, Annie. A pleasure as ever. And I would just say to listeners of this podcast, on the URM website at www.urmconsulting.com, there is a blog called GDPR Back to Basics, which I wrote a while ago, which includes the topics that we've been discussing on this podcast, as well as a few more. And I would recommend that blog to you if you're interested in following up the topics of this podcast and more.
Thank you very, very much, Stuart. Lots of really interesting stuff to think about there. Thank you very much for coming along.
You're welcome, Annie, and I look forward to speaking again on the next URM podcast.
Thank you. If you've enjoyed this podcast, we would really appreciate it if you could spare a moment to leave a rating or review at ratethispodcast.com/InfoSec Insider. To listen to more episodes, you can find us on Spotify, Apple Podcasts, YouTube, and Podbean.
Thank you for listening to URM's InfoSec Insider podcast. For more information, visit our website at urmconsulting.com.